When people become engaged in a dispute, it becomes necessary to find a means to resolve the dispute. This is where attorneys can provide a necessary service. At the outset, it must be emphasized that litigation is simply a means of resolving disputes. Attorneys must focus on the fact that when they litigate on behalf of a client, the object is to resolve the dispute. It is worth pointing out that disputes, irrespective of the nature, can be resolved without going to court. Where this can be achieved, it will be in the best interests of the client for the attorney to do so. This is what Lord Woolf had to say about litigation. Civil litigation should be avoided where possible, less adversarial and more cooperative, less complex, more certain with shorter timescales, and more affordable, predictable, and proportionate. That sums up the modern approach to litigation. To put it plainly, litigation must achieve its purpose. That is, the dispute must be resolved quickly and cheaply in a less adversarial manner. Litigation practice is changing dramatically. Attorneys have to reconsider how they conduct their practices in an ever-changing civil justice environment. The whole approach to dispute resolution is undergoing a complete transformation. Litigation is simply a means of resolving disputes. It should not take too long, and it should not be so expensive as to become the preserve of the well-off in society. The modern approach to litigation is for the parties, especially the attorneys representing the parties, to focus squarely on the substance of the dispute. The object is to resolve the dispute quickly and cheaply. In fact, we have now redefined what is meant by access to justice. Access to justice simply means the way we resolve disputes. Attorneys will come under the impact of two factors: contingency litigation and case management. The latter involves judicial intervention, the object of which is to make litigation quicker, cheaper, and less adversarial. To be successful, an attorney's practice must focus on two elements: an efficient administration that is part of a good practice management policy, and sound litigation and dispute resolution technique. You must have both, not one or the other. You cannot make good money in litigation only to dissipate your fees through poor administration. It pays to note that litigation is competitive, and you have to deliver a consistent high standard in order to maintain a sustainable practice. There is no room left for the mediocre. The major drivers of change are contingency litigation and case management. Both of these factors are now a reality, and in order to be a successful litigation attorney, you have to transform your practice to accommodate these developments. Whilst a law firm should be firmly committed to addressing the best interests of the client, it remains a business, and it must provide an income for those who work in it. Here are 10 objectives that will make your firm more efficient, bearing in mind that a significant portion of the litigation you undertake will be on a contingency basis. Have an improved litigation management process. Have an effective case management process. Avoid having dissatisfied clients. Avoid having to carry excessive write-offs. Avoid poor budgeting. Have better client communication. Have an effective billing system. Have a system to monitor and control operational expenses. Have a system to monitor financing costs and cash flow. And Develop an effective IT system, one that suits the needs of your law firm. Access to electronic media is essential. Case management and contingency litigation will cause changes to the business dynamics of your law firm. Like any other business, a litigation practice must have a business plan. Here are 10 items that you must include in your business plan. Being able to anticipate future scope, needs and expenses of every case you take on, and to carry out efficient cost-benefit analysis on a case-by-case basis. Being able to provide consistent high-quality work at a lower per-case cost. Develop current and accurate information for the client at every phase of the case. Improve client awareness and understanding. Manage client expectations at a realistic level. Enhance the firm's reputation as a successful litigation unit. Generate improved fee income from client satisfaction and efficient management of resources. Focus on resolving the dispute. Avoid interlocutory disputes and avoid falling foul of time bars from court rules to prescription. You must recognize that no two cases are the same. Each lawsuit is different regarding the facts and the application of the law. At the same time, the attorney-client dynamic or relationship will equally differ from case to case. Please remember that as an attorney, when dealing with a dispute, conduct yourself strictly within the rules of ethics. Throughout the world, and including our country, the preferred method of conducting litigation is within a case management regime. This regime involves early judicial intervention and requires the parties to litigation to focus on the facts and to identify the dispute at an early stage. Once the dispute is identified, the focus shifts to resolving it as soon as possible, thereby avoiding unnecessary costs. Interlocutory disputes are to be avoided. Case management has been introduced in our high courts, and we urge you to consult the practice directives in the division where you practice. You are now expected to apply your mind to alternate dispute resolution in the form of settlement, negotiation, mediation, and arbitration. This will become part of the civil justice system, and attorneys will be encouraged to use these methods to resolve the dispute before resorting to an adversarial hearing in a court. Alternative dispute resolution, ADR, is becoming more prominent within the civil justice system. Attorneys have to get used to this. Parties are encouraged to attend conferences or meetings where matters could be settled. The concept of mandatory ADR is being introduced in our civil justice system. For example, compulsory settlement conferences. Remember, the modern approach to litigation is for the parties, especially the attorneys representing the parties, to focus squarely on the substance of the dispute. The object is to resolve the dispute quickly and cheaply. Litigation no longer takes 3 to 6 years. That is not access to justice. Already in the Gauteng Provincial Division, cases can be finalized within 1 year. This is being achieved through case management. Case management is based on the principle that only genuine disputes be dealt with in our courts. The system works on the basis that the parties are forced to identify exactly what the issue is between them. Vague, formulaic, precedent-based pleadings will no longer be tolerated. Here are some reforms that are currently being considered by the judiciary. Cases should be allocated on filing. Continuous judicial control over a case through judicial officers and support staff. Initial and more pre-trial conferences should be overseen by judicial officers, which would assist parties to come to some agreement about the issues. Once there is a commitment to the issues, these are difficult to change, which leads to a quicker resolution of a case. Trial dates should be allocated accordingly. Settlements should be encouraged. And effective information systems should be employed. Note that some of these proposals have already been put in place in Gauteng. Litigation is undergoing exciting changes. It is the dynamic attorney who will embrace these changes and sustain a successful practice.